For decades, it's been a major obstacle in litigating specific cases in the United States. The executive assertion of the state secret privilege, which restricts lawsuits most times dealing with rendition, torture, warrantless wiretapping, and espionage by denying evidence classified by the American government. The most recent example of the state secret doctrine, the dismissal of the two AIPAC lobbyists who were indicted for conspiracy to commit espionage on behalf of Israel. The Justice Department urged the courts to drop the charges against the lobbyists because evidence against them would reveal national security secrets. Some politicians in Washington are looking to change this system.
Some members of Congress have introduced the State Secrets Protection Act of 2009 to prevent the litigation process of some cases from being finalized. The bill would allow a selective panel of lawyers, including the judge, to review the classified information.
We still need legislation on the other end, because no matter what the president or the attorney general, this one or ones in the future do, we need to direct the courts to actually look at the information that the executive is trying to shield and make an independent determination about whether releasing that information to the litigants truly would endanger national security.
Prominent members of both chambers of Congress are pushing S-417 and H.R. 984 to pressure the administration to reverse the state secret doctrine under the Bush administration.
And all we're asking is that it's no longer an either-or situation and that courts are directed to try to find a middle ground that would protect the information but let the case go forward in some sort of manner.
They have embraced the same view as the Bush administration. This isn't a partisan issue, it's just about protecting the country.
But some in Washington say the bill will most likely go nowhere because the state secret privilege is reserved under certain provisions of the U.S. Constitution and remains a matter of the executive branch only.
This legislation is going nowhere. The Obama administration strongly opposes it. And indeed has been unwilling to even send anyone to make public comments on it one way or the other. The Obama administration wants to keep this issue, rightfully so, inside the administration, and to that end is undertaking a review of its use of the state secrets privilege.
Critics say the Obama camp is recycling the state secret policies enforced under the Bush administration with no signs of modifying the system to ensure pending lawsuits produce end results. Constitutional and detainee lawyers say the Obama Justice Department is not making their litigation easier, but making it more difficult for justice in their cases to be reached. Jehan Hafiz, Press TV, Washington.